Good morning, everyone. My name is Grace. Today, our topic for this presentation is mental harm from negligence, a complex and involving area of tort law concerning compensation for mental harm. Unlike physical injuries, psychiatric harm is more difficult to prove. The interest group considered its individuals who suffer mental harm as a result of negligence. Mental harm is a serious physical or mental condition caused by an event which may take the form of various recognized psychiatric illness, including phobic anxiety or post-traumatic stress disorder. The liability issue at stake is whether and to that extent the law of negligence in Queensland recognizes and compensates such harm. This question remains significant given the Civil Liability Act imposes strict thresholds for recovery, including requirement of forcibility, control mechanism, and proof of recognized psychiatric illness. The issue matters because mental health problems are increasing in Australia. Research indicates that nearly half of all Australians will experience a mental health disorder in their lifetime, with anxiety and a post-traumatic stress disorder among the most common. A significant proportion of these conditions are triggered by traumatic events, such as road accidents or workplace incident. The cost to society is substantial. The Productive Commission estimate that mental ill health costs the Australian economy up to 70 billion annually in direct services, lost productivity, and social support. Moreover, compensation limits hurt victims and costs to society. Queensland law does give some help to people who suffer mental harm, but the rules are too strict and don't match modern medical knowledge about mental health. And the process of seeking compensation is often very time-consuming and costly. Many victims miss out on fair compensation. The law should be reformed to ensure greater protection for victims and provide a quicker, more effective process for making compensation claims, while still preventing false or weak claims. Mental harm in Australia is usually litigated in employment accident or public authority content or traffic accident. In Hans and Barry, the English Court of Appeal held that a wife who witnessed a car accident could recover compensation for mental harm provided she proved a recognized psychiatric illness. In case Weeks and State Rail Authority New South Wales, 2 police officers claimed psychiatric injury resulting from a State Rail Authority's negligence, faulty safety device in causing the accident. It clarified the pure psychiatric injury under New South Wales, who witnessed instant event. Mental harm in Australia, including Queensland, usually litigated in employment, accident, or public authority contents. In Hans and Barry, an Old English case, the English Court of Appeal held that the wife who witnessed a fatal car accident could recover compensation for mental harm, provided she proved a recognized psychiatric illness. In another case in New South Wales, Weeks and State Rail Authority New South Wales, 2 police officers claimed psychiatric injury resulting a rescue job from an accident. It clarified liability for pure psychiatric injury under New South Wales law is not strictly limited to those who witness an event. Tam and New South Wales 2002, page 211, Commonwealth Law Report 317, psychiatric illness claim failed, showing the high threshold. Caddy and Toll Proprietary Limited, 2024, New South Wales Report, page 120. Bullying harassment claim failed as psychiatric harm, not force. There are 5 elements of negligence in Torts Law: duty of care, breach the duty, causation, damage, and no defenses. In a significant court case, it's called Elisha Limited, the High Court ruled that such psychiatric injury from unfair dismissal can be compensable. Vision breached its disciplinary procedure, causing Mr. Elisha's mental harm. First, the employer owed the employee, Mr. Elisha, a duty of care during the employment. Second, Vision Australia breached the duty of care. Third, the court held that psychiatric injury is a form of physical and personal injury, recoverable as damage for breach of contract and negligence. Fourth, another test for when a loss will not be too remote to be recovered as damages for breach of contract contain 2 lines of the original expression of the test given by Alderson B. in Hartley by Baxter. First, losses that arise naturally from the breach, in the usual case of things. Second, losses resulting from special circumstances known to both parties at the time of contracting. Fifth, damage. Elisha suffers damages from this matter. Sixth, no defense will available. In this case, Elisha doesn't engage any wrongful conduct. The Elisha case showed that legal system is capable of fairly compensating such psychiatric injury where all the required elements are satisfied. However, the Elisha and Vision Australia Limited case shows problems in psychiatric injury claims. It took nearly 9 years through the 3 courts: Supreme Court of Victoria, Appeal to Court Victoria, and then the High Court. The legal cost and the stress for the Mr. Elisha, it's a lot. So, therefore, for the people in weak position, like they are not capable or they have very poor situation to pay all the legal costs, so we need some help for them. Weller, Popper, Walsh, Buckley, Cook, and Bailey's 2024 article takes a wider view and shows that negligence law often lets people down, especially after the LPP reform. The limits on the mental harm reliance on peer opinion and protection for public bodies make claims harder. Many cases end up in weak compliance system instead of proper compensation. Kyler and Cerebrals Australian Limited. Miss Kyler developed psychiatric illness due to heavy workload. The High Court dismissed Miss Kyler's claim and held risk of psychiatric injury is not reasonably foreseeable in those circumstances. This shows how mental harm claims often fail because the foreseeability is hard to establish. Scherer and I Select Service Proprietary Limited shows limitations on employer duty for mental harm, especially when risk is not obvious. Adamson and All's New South Wales case, a worker claimed psychiatric injury due to co-workers' racist behavior. The court found that the risk was not reasonable foreseeable because the worker did not display signs to the employer and that employer acted under the policy once the complaint was raised. Supports the idea that even when harm occurs, claims are often rejected because the employer had no indication of risk or because the preventative steps were taken. Reflects reliance on employees shows signs and legal protection for employer if they follow procedure. Guilford and Strand Patrick is another case, Australian case, which confirmed that employers' duty of care extends not only to employees but also to their close family members. Well, psychiatric injury is a reasonable, forcible consequence of the employee's death caused by negligence. Suggested reforms. Relax the recognized psychiatric illness requirements. Current law demands medical diagnosis, which it overly narrowed access formal psychiatric illness to justice for psychiatric harm, relaxing strict evidentiary rules so serious grief or anxiety can be treated as the damage. The second reform, burden forcibility test. Reform could focus instead on whether psychiatric harm was a real and not far-fetched risk, aligned with modern torts theory of corrective justice, repairing wrongful losses. Third, review protection for public authorities. Public bodies often enjoy broad immunities under Civil Liability Act. Limiting recovering weeks and stay real authority shows the difficulty. Reform should balance floodgate concern with fairness for victims' families. Fourth, consider alternative system of compensation. Many people who suffer psychiatric harm are vulnerable and cannot manage costly, complex litigation. Reform in Australia should make access easier by creating a non-fault compensation scheme for mental harm, similar to New Zealand's ACC, and expanding legal aids and for mental health claimants. Conclusion. This presentation has examined the development and shortcoming of Australian negligence law in relation to psychiatric injury. While the law now recognizes mental harm as a legitimate basis for compensation, it remains bound by rigid such as need for a formally diagnosed psychiatric illness, narrow forcibility rules, and the strong protection for employers and public bodies. Academic commentary highlights that many genial sufferers continue to be excluded from justice. Research shows that litigation in this area most often arises in workplace, accident, or public authority contexts, leaving significant gaps for those outside these categories. To address this shortcoming, reform should include creating a no-fault compensation scheme, expanding access to legal aids and advocacy, and easing evidentiary requirements so that serious grief and anxiety can be treated with equal seriousness. Such reforms would better reflect the principle of corrective and distributive justice and ensure that vulnerable claimants are not left without remedy in an area of growing social concern. Thank you.